Priscilla Pomau, Dr. Lavinia Tico, Miss Anaseni Raibode, Mr. Luke Sermasanga, Miss Miriama Ara, and Mr. Vereti Ndoi. Please join us in welcoming the members of the Education Commission and the Secretariat's support staff. Thank you very much for availing ourselves. I won't take too much time, but before that, I'll introduce the members of the committee. Furthest to the right is the Assistant Minister for Itauki Affairs, the Honorable Ratu Iskeli Tuelebu. Just next to him, former Minister and a member of the Opposition, Honorable Chone Usmate. Next to him, the Assistant Minister for Finance and Business Development, Honorable Sachidanand. And just next to him, former Minister, a member of the committee and also a member of the Opposition, Honorable Fayez Koya. Myself, as Chairman, Ratu Rakuita Bakalalambure. And there's another member of the committee who's tuning in virtually, Ratu Choseya Nyundamu, who's the Assistant Minister for Justice. So we welcome you. Thank you very much for coming in this afternoon. So we won't take too much time. I understand you have submissions for the committee, and I'll now give the floor to Professor Naidu. You have the floor, sir, and the members are open to question anytime as we go. I beg your indulgence on that. Thank you. You have the floor, sir.
Thank you very much, Honorable Chair and Honorable members of the Parliamentary Standing Committee on Justice, Law and Human Rights. So, you have introduced us already, sir, so there is no need for me to go over the names again. The Fiji Education Commission was appointed by the Honorable Minister for Education on the 1st of July, 2025, for a 12-month term to conduct an independent examination of Fiji's educational system, which included the early childhood education and development centers, primary and secondary schools, special and inclusive schools, teacher training institutions, and Tibet institutions. We have engaged in school visits, and by this stage, it's over 90 schools, urban, rural, remote, very remote, under different types of ownership, and in a stratified and complex sampling that will represent the 1,800 to 2,000 schools that we have in Fiji. And then, of course, all the divisions, and this far we have consulted with 2,000 stakeholders. And this includes officials of the Ministry of Education, statutory bodies, including the Fiji Teachers Registration Authority, Treasury Students Loan Services, Higher Education Commission of Fiji, Substance Abuse Advisory Council, professional associations, teachers' unions, civil society and faith-based organizations, and development partners. As those of you who have gray hairs and bald head like me, you would know that the last Education Commission was established in 2000. So it's a long, almost 26 years since then. So in making our submission, we have looked at a number of documents, including the terms of reference for the review of Fiji Education Act 1966, the Education Act Review Commission's policy issues paper, 1966, the 2023 Denarau Declaration, and Fiji's 10-year education, Fiji's 10-year National Education Policy Framework, 2024 to 2033, developed through the Fiji National Education Summit and the Fiji Education Bill number 34 of 2025, and the Constitution of the Republic of Fiji 2013, and particularly Section 31, right to education, and related provisions of the Bill of Rights. In our submission, we have written submission. We have 44 findings, but mindful of the constraint of time, my colleagues and I, we have a division of labor, and we'll share with you orally, if time permits, 21 findings. And the report itself covers these findings, 9 areas where the bill could be strengthened to better align with the Constitution, and 12 observations of concern. So the Commission has undertaken a very thorough analysis of the draft education bill and offers these observations this afternoon in a constructive spirit. Our purpose is to assist your committee, sir, in strengthening the legislation so that it serves the children, teachers, and communities of Fiji well for the coming years ahead. So I'll pass on the to begin the first set of submission.
Thank you, Chair, the Honourable Chair and Honourable Members of the Parliamentary Standing Committee. With reference to Clause 7 and 8, the right to free education, we note that Clause 7A recognizes the right to early childhood education. And however, Clause 8 guarantees free education only for primary, secondary, and higher education. In early childhood, ECD is omitted from Clause 8. And the bill recognizes a right without corresponding funding mechanism. And we recommend the replacement first, number one, the replacement of the terminology ECED, Early Childhood Education and Development, with Early Childhood Education, as was before ECE, in some cases ECEC, and in some cases ECCE. And throughout the bill, we wanted the ECED to be mentioned throughout the bill because this is, it aligns with international standards like UNESCO, UNICEF. And insert a new clause, 8.4, the government shall provide free early childhood education and development to all children with particular attention to rural, maritime, and disadvantaged communities. And this mirrors the approach already used for secondary, primary, and higher education in clauses 8.2 and 3. And that's for, if we have our booklet up on page 3, I'll move on to number 7, clause 9. And with reference to clause 9, the bill defines school narrowly in clause 3 to cover only formal schools. And the program serving out-of-school children of primary age, teen mothers, working youth, and persons with disabilities have no legal recognition. And they cannot receive government funding and cannot issue recognized certificates. And this population remain outside the formal education system. And our recommendation is to insert a new provision to formally recognize alternative education providers that offer programs for children and young children unable to access conventional schools. 2, this should include second chance education, community learning centers, workplace-based learning, distance learning, and cooperation with accredited higher education institutions for the purpose of certification. And recognized providers should be eligible for government funding, subject to meeting quality standards and reporting requirements.
Thank you. Honorable Chair and members. The next point is point number 8 in our submission, and I'd like to talk about clause number 10 of the bill, which relates to compulsory education. Currently, clause 10 requires students of compulsory school age to attend school full-time, as per the law legally. There is no legal way for a student to attend school part-time and undertake an approved apprenticeship or work integrated learning part-time. In practice, students may need to choose between academic school and practical training. So currently the law provides that a student should attend school full-time. What we are suggesting is, one of our recommendations is to amend clause 10 and provide that attendance at an approved apprenticeship or work integrated learning program combined with continued schooling satisfies compulsory education requirements. And the second recommendation is that the program must be approved by the permanent secretary, include prescribed educational components, and lead to a recognized qualification. And then over the page, item number 9, again, it talks about clauses 10 to 12, compulsory education in the bill. Currently, there is no system to track dropouts or help students return back into schools. Under Part 3 only punishes non-attendance, but provides no framework for understanding why students drop out, preventing dropout, or helping students return. Teen mothers, working children, and expelled students have no legal pathway back to education. That is the issue currently. So what we are recommending is 3 recommendations. Create a dropout monitoring and re-entry duty into the Act. 1, require systems to monitor dropout rates and causes and identify at-risk students. 2, require re-entry pathways for out-of-school children and youth, including flexible learning options and removal of re-enrollment barriers. And 3, require schools to report students who cease attending. So those are the 3 recommendations under that clauses 10 to 12. Thank you.
So just a question on that. Compulsory education, the introduction of criminalization of parents, no? Punishment of parents may be punished to 1 year imprisonment or a fine of $2,000 in the bill. What is the view of the Commission on that? Do you support that parents be criminalized? I'm just looking at your submission. You haven't stated anything about that, so I'm just putting this question forward to the Commission. What is the view of the Commission on the penalty that is being imposed to parents if children are not going to school, which if you can see on the screen, a fine of $2,000 or imprisonment of a term not exceeding 12 months. So for the benefit of the committee, what is the view of the Commission? Thank you.
Thank you, Honorable Chairman. We actually discussed this matter and feel that this is an inappropriate and disproportionate penalty against parents. We, in our discussions, we are suggesting that there should be some investigation made on why there is prolonged absenteeism, and the steps should be taken ahead of this criminalization process. And the steps would include warning the parents, bringing the parents up to the authorities to explain what is going, because circumstances can vary quite considerably on the ground, the realities of how families and households are coping with their circumstances. So we believe that there should be a step-by-step procedure towards handling this matter rather than a summary action to punish. And in fact, towards the end of our submission, we make the point that many of the penalties being imposed are disproportionate and are not particularly consistent across different types of offenses.
We had asked this question to the ministry, and the drafters have highlighted that the steps are already in the bill. If I can just turn your attention to the bill on the screen, Jackson. According to them, that's the steps. So I go one from one. So compulsory education, 1, 2, 3. So at 3 is where the steps, according to the ministry and the drafters, have been highlighted. Okay, if a child of compulsory age is not enrolled in school, A, the PS must take reasonable measures. B, the PS is not satisfied with the reasonable compliance. PS must direct either parent or both parents of the child to immediately enroll the child in school. Next. And then fourth, if the child of compulsory is not enrolled in school and fails to regularly attend school, A, PS must take reasonable measures to make reasonable inquiries. B, if the PS is not satisfied with the reason of non-compliance, must direct either parent or both parents of the child to ensure that the child is regularly attend school. And then the fifth one, the PS must apply to a magistrate for a compulsory education order, if those are the grounds. A directive has been issued and the parents do not follow. Despite the directive, the child is still not going to school. And the compulsory education order from the court takes place at 6. And if non-compliance of the compulsory education order granted by the court, the parents do not comply with that, then 7 applies, where parents are taken to task. Those are the steps that they have. Is that sufficient?
Yeah, I think so, Honorable Chair, because you've taken these different steps to ensure compliance, and if they still don't comply, and the penalty is not exceeding 2,000, which is not particularly out of the alignment of the other penalties that you have.
I ask these questions, sir, because in the current act, there's none of this. This is totally new, being introduced. The question probably that we need to ponder about, will this be effective or is this a deterrent? Because even the current bill, the current act doesn't have this and it's not working. If we have this, will it work? Will probably more prisons will be full with the parents? If the parents are taken into prison, who looks after the child? All those questions come after that. But thank you very much. Yes, ma'am, you have something to say?
Thank you, Chair. Yes, I just want to add that this new policy that has just been passed around the repeat policy, that if students are not particularly doing well in this grade and also has not fulfilled a particular percentage, if they are absent more than 20 days, then, they can, in discussion with the parent and the school, allow the child to repeat. I believe, sir, that this has already had really good impact on children's attendance, because there are steps that schools are following now based on the policy that flags the attendance on the FEMIS. That if they're absent 5 days, there are steps the schools to take, call the parents in, talk to them. But also, more importantly, the schools are carrying out awareness programs with the parents. And so we already have seen from the schools that we have visited, it's already taking effect. So I think that, this will enable compliance, and if not, then they should pay whatever fine. Thank you.
So just last one from you, Honorable Nunn. Are you okay with what the fine is being proposed? $2,000 or a term of 1 year imprisonment? Are you okay with that? What's the view of the Education Commission on that? It's either you pay $2,000 or imprisonment of exceeding 12 months in prison, or you can be both, serve time and pay $2,000. Is that sufficient? In your opinion, is it too harsh or is it too lenient?
I suppose the qualifier is not exceeding 2,000. So presumably the magistrate has discretion in terms of the actual fine. So this may help. But there are all sorts of parents, and sometimes there's follow up on absenting students. Teachers go to parents' home and they get chased by the parents. So I think this may act as a good deterrent.
Thank you, Chair. I'm just leading from the Chair's question. My question to the Commission is, what are your views on criminalizing the whole thing, that the parent would have a criminal conviction if he or if they are unable to or do not send their child to school? Fine is one thing, but criminalizing the parents is another thing. So what are your views? Whether fines is sufficient, and then if they are unable to pay the fine, then the parent to court, and then the legal system kicks in? Or because otherwise my fear is we are criminalizing almost everything. And our jails will be full of parents if they don't send the kids to school. I mean, after exhausting all the process. But do you think criminalizing the parent would be good, or just sticking to the fine? Because why I'm saying that, probably the team is unaware, we have another bill which is called Criminal Records Bill. So where we are trying to give people a second chance. And here we are trying to create people with criminal records. So what are your views? I'm sorry you are not privy to the Criminal Records Bill, but please, your opinion on that would be great.
To you, Chair, Honorable Sachidanand, I think that's a very valid question. And already, as we all know, that our prison system's overcrowded. And we don't want to, as the Chair said, put parents into that situation. So, in terms of our discussion, I'm quite happy to say we should have this criminalization or conviction and being sent to jail as the very last step. So I would go along with your suggestion, and I don't see our commissioners objecting to the financial penalties coming first.
Chair, just to get a bit more of a finer point on it, do you believe that it should be criminalized or not? Or should you just leave it at fine? And I say that because what if you really had an errant child and you're a perfectly good parent, or parents for that matter, law-abiding citizens, all that kind of stuff, and all the avenues that have taken place have gone through, but you've got an errant child who's just continuously done not or been an error, not been to school, etc. And then worst case scenario, does that parent still get done and have a criminal offense against his or her or their names? Your opinion matters. You are the Education Commission. So when you say that as a last resort, that's fine. But do you believe that we should not go down the road of making it a criminal offense? Maybe we should stop it at fine? What are your thoughts?
I'd like to respond. I think given the rigorous steps that are in place to ensure compliance by parents, there would be some extraordinary reasons why the parent is not bringing the child or ensuring the child comes to school. I would not like to see parents criminalized in this matter. I'm quite happy with just the fine.
I think we'll concur with the view, Mr. Koya. Thank you very much.
Just a final question from me, whilst we are still at compulsory education. I'm sure you are well aware that compulsory education will be only limited to the age of 15. Are you aware? No. Oh, interestingly. Okay. Okay, so no, the current act, I've seen the submission that you wish to propose to raise it up to 17. Yes, the ministry had highlighted that it be compulsory education only up to the age of 15. I had raised this with them. I wish to raise this with you and see what are your views on this. The reason being is the one is for the consistency with the Employment Act law. The Employment Act law allows 16-year-old to work. So that's why they've lifted it, the compulsory education, to only 15 years. Now, the concern that I raised with them is the issue of best interest of the child. And the logic behind it. The whole idea of, for one to go to school is to finish school. Okay? And secondly, I just informed them, currently, there are no Fiji intermediate exams, there are no Fiji 8th-year exams, there are no Fiji junior certificate exams. The child can go out. Okay? So by the time the child leaves the education system, they haven't gone through any form of educational assessment. And for now, if someone wants to work, whether it be private or public sector, the minimum that they ask you is Form 6 pass. You want to go into the police, the Fiji Correction Services, the minimum that they ask for you is Form 6 pass. I was raising this with the ministry to find the logic behind it, the logic. If we are pushing for an educated Fiji, the logic behind this and the compulsory, they seem to contradict each other, in my opinion. In my opinion. Because all employment, whether it be the private sector or the public sector, the minimum they go for is Form 6 pass. But this compulsory education, if you it limits to 15-year-old, that's year 10, most probably Form 4. They haven't done any assessment. So what are your thoughts on that? Because upon our discussions, they wish to maintain that because so that it can be consistent with the Employment Act. I've seen in your submission that you wish to elevate it to 17. Okay, what are your views on that? Because the logic behind compulsory education of any parent or for anyone, finish your studies. Okay, any thoughts on that?
Honorable Chair, I refer this matter to Mr. Maharaj, who also is a private sector person in the...
The reason, one of the reasons why we had wanted to push it up to 17 was the very comment that you made, that they need to finish year 12. And that was the reasoning behind our putting that number on our recommendations. But you are correct, 16 is the legal working age. And I think it's food for thought at this point in time. We haven't really looked at both the acts, both the legal provisions. But I think the number can be reviewed, and it's important that we align it to the other acts. Whether the other act needs to put it up to 17, or this act puts it down to 16. But we thought that year 12 was important, and we were debating as to what is the age of the student when they reach year 12, and then we had agreed that it should be 17. But sometimes they also, repeat. That's the other issue.
Honorable Chair, if I can add on to that, I think it is very important for countries such as Fiji to have an educated population. So I would agree that once a child completes higher education, then that would be a better age group to think about. But we need to think about that Fiji will need an educated population. Thank you.
Thank you. Any other comments? None. Thank you. Professor Naidu, you can move on with any other submissions?
Thank you, Honorable Chair and honorable members of the committee. Our next one is number 10. which refers to clauses 23 to 33, but mainly on clause 24. This is under part 5 on the curriculum and assessment, curriculum development and assessment. And we are looking at the establishment, which is clause 24, the establishment of the National Curriculum and Assessment Authority. And we feel that the bill lacks independence, the legal status, and governance safeguards. Both from the Narrow Declaration as well as the Education Commission report of 2000, they have consistently come up with an independent, autonomous body for curriculum and assessment. So although there is a National Curriculum Assessment Authority, what we are looking at is to have an independent, autonomous body, which would be a body corporate. At the moment, it does not have any body corporate, has no legal personality, and is chaired by the Permanent Secretary, Clause 25, 1A, and that is on page 20 of the bill. An independent autonomous body, as you all know, it's created by law and funded by government, but is protected from day-to-day political or ministerial control. So that's the whole idea of making this authority to be an independent, autonomous body. So we have some recommendations there. One is to establish the authority as a body corporate with perpetual succession, mirroring at the moment we have about 4 statutory bodies, and we're looking at these to be similar, the governance to be similar as other statutory bodies. One is the Higher Education Commission of Fiji. The other one is the FTRA, the Fiji Teachers Registration Authority. The third one is the Tertiary Scholarship Loans Services. And the fourth one is the Substance Abuse Advisory Council. So that's in the bill is in clause 128 for higher education and clause 84 for the FTRA. And the second recommendation is that the authority should be governed by a board of 7 to 9 members appointed through a transparent, skills-based process by the Minister for Education. And to have members, so we have the authority, but we have a governing body, which is a board. And also the representatives. We have a list of, I think in the, yes, on page 20, that the membership of the authority, we have, we are requesting that the chairperson be somebody else and not the permanent secretary. The permanent secretary should be a member, but not the chairperson. And we include reps from the ECE, SIE, also some from governance or legal expertise. And the third recommendation is to insert an independence clause. So in performing its functions, the authority shall act independently and shall not be subject to direction by the minister or the permanent secretary in respect of technical, professional, or operational decisions relating to curriculum content, assessment standards or examination outcomes. And the fourth recommendation is to insert a finance division that mirrors what is currently in place for the Higher Education Commission, that is clause 153 and 156. And we report, or the authority will be reporting to the to Parliament through the Minister for Education, and require annual reports with audited financial statements subject to Auditor General oversight to be tabled also in Parliament. And also to include the functions of the current functions of the curriculum and assessment divisions to be part of this authority. Thank you, Honorable Chair and members of the honorable members of the committee.
This is one issue that we just discussed with the ministry just now. Because if you look at all of the other bodies, that they have these specific provisions to set up a body, whereas in this one, they have not specifically said that there should be a body set up. One of the suggestions that they made, maybe there will be people that are seconded from various parts into that unit. So in the way that you're presenting it, that you feel that it needs to be a separate body with its own staff and so forth. And can you just point out why is it that that needs to be the way that it should be, rather than the way they've presented it now? In the bill, it says you find a way to implement this, but that might not necessarily mean setting up a separate body on its own. That's the way it's currently written in the bill. So what are your thoughts on that?
The independence would mean that, like the other statutory bodies, so that we don't have any other interference from government, from the for instance, what is happening, what we have seen, one government comes in, reintroduces scaling, another government comes in, removes scaling. So that is what we are trying to do here, so that there is no interference in the running of, and also because these two work together, the two curriculum, and as you will know, assessment. And so, and we feel that having an independent body, like other countries, for instance, New Zealand, they have that New Zealand Qualifications Authority, but the minister appoints the board. Australia, they have an Australian Curriculum Assessment and Reporting Authority. So it's also independent. So when I say independent, it's independent in the independent political. That is the whole idea behind this.
Chair, if I may add to what Ms. Raibode has said, there's a strong agreement in the Commission that education should have its own pathway. There should be very little interference, political interference, and this National Curriculum and Assessment Authority is supposed to be a very strong body. And it looks at the curriculum and keeps changing the curriculum and so on. So we feel that education should not have too much interference with the government of the day and as governments change. That was the general consensus by the Commission. So I just wanted to share that.
Honorable Chair and honorable members of the committee, just number 11, that clause 23 is still part of this authority. One of the things that is coming up now is a number of providers for early childhood education, both private and non-private ones. And what we are looking at in this one is to have some sort of a regulator, but to start off with just a framework. So at the moment, there is nothing at all to regulate all these providers for the early childhood education. So it says Fiji has no legislated quality assurance system for early childhood education and development services. International comparators such as Australian Children's Education and Care Quality Authority in Australia, the Education Review Office in New Zealand, and the Office for Standards and in Education, Children's Services and Skills, the Ofsted in UK, they all operate under enabling legislation. So we feel that without a statutory mandate, ECED, which is the Early Childhood Education Development Quality Standards, will remain fragmented and unenforceable. So the whole idea, Honourable Chair, is to try and within this particular independent authority to have some sort of framework called the ECED Quality Assurance Framework that will look after the registration and licensing standards, curriculum expectations, workforce qualifications for qualification standards, and also monitor the improvement of these institutions. And that's the first recommendations, and the second one is to also the framework content should be prescribed in regulations and also published, because the standards will keep on changing, so that can be part of that framework. Thank you, Honourable Chair.
It would be something that you would insert under the curriculum authority, these requirements?
Yes, Honourable Member, Honourable Osamate, that we are looking at that to be part of one of the functions of the authority, because it deals with quality assurance. Thank you.
Thank you, Chair. The next point is number 12. It refers to clause number 23, curriculum. Clause 23.3a mentions digital literacy and learning, including artificial intelligence. And that is all. Just very minimum. But does not explicitly cover cyber safety, online protection, or responsible digital citizenship. So what we're calling for is to strengthen the digital literacy provision. One, expand clause 23.3a to explicitly include cyber safety education, responsible digital citizenship, and online protection. And two, require the Minister of Education to prescribe minimum technology and connectivity standards for schools, recognizing that the digital divide between urban and rural schools must be addressed. So we felt that this should be in the Act and has to be very explicit. Minaka.
Comments? Any? No?
I move on, Chair. Next point is number 13. It refers to clauses 23 and 29, curriculum and language. It talks about indigenous language rights and it has no legal protection at the moment. So the bill includes the formal learning of Vosavakaviti and Hindi as a curriculum thematic area, but is silent on the language of instruction. There is no law preventing a future minister, say for example, from requiring English-only instruction from the first day of school. So international research consistently shows that children learn better when taught in their mother tongue first. The bill also does not expressly state that these languages are compulsory subjects in all primary schools as required by the Constitution, Section 31(3). So what we are saying is to protect the mother tongue education. Number one, require the National Curriculum Framework to make compulsory provision for mother tongue instruction in ECED and the early years of primary education, perhaps up to year 3, with progressive transition to English as the primary language of instruction. And two, mother tongue should include Itoke, Hindi, and other languages spoken by students in their homes and communities. 3. Schools should remain free to teach English alongside mother tongue instruction from the earliest stages. So what we want to do is to spell that out, so that gives the legal foundation as to how it should be taught. Naka.
Yes, Chair. Sorry. When you're talking about mother tongue, the bill says Vosavakaviti and Hindi. Now, for the Indo-Fijian community, what would you classify as mother tongue? Fiji Hindi, that we speak at home, or the real Sanskrit Hindi where all our literatures and resources are? What would you classify as mother tongue for delivery of Hindi?
Good question. Thank you, Honorable Member. In my personal view, to be honest, we haven't actually discussed that, which Hindi it should be, to be honest. But in my personal view is that it should be the real Sanskrit Hindi that is taught normally in all the literature, all the books. Fiji Hindi is spoken openly. I don't see any merit in teaching Fiji Hindi. The Hindi should be Hindi itself, the original Hindi. That's my personal view, Naka.
Chair? How do you balance that against the compulsion in the Constitution regarding Fiji Hindi? And it is a well-known fact that there are many other races and religions in Fiji that teach. What about Chinese? What about Rotuman? What about all those other minorities that speak other languages? That's going to be missing. If you're talking about, look, there is a big argument or discussion regarding Fiji Hindi and Itoke. Even Itoke has many different versions. If you're talking about literature, we have different opinions. You're talking about literature, of course there's no literature with respect to Fiji Hindi, because it is a concoction of many different versions of Hindi, and Urdu, and Sanskrit, and Tamil, etc. All of those things. Itoke is the same. The basis of the Itoke language, when it's written, is written in the English alphabet. So you have to weigh all of that up before you make those kinds of statements, or you cater for all of them. The thing is that your start point is, the Constitution says, conversant Itoke and conversant Fiji Hindi. You need to develop it so that it does become formalized. That's what's being told to us with respect to the Constitution, that is to be taught with compulsion in the institutions, in the schools. So there's a balance there that we have to find. There are look. You would know this, sir, both of you, that there are many religious-based schools that are very, very large, have many schools. Some won't even teach Hindi. Some won't teach Urdu. Some won't teach anything. Some will only teach, the Chinese school teaches Chinese. So how do you accommodate all of that with respect to your thoughts on that particular provision?
Thank you, Honorable Koya. Good insights. Now I recall that the Constitution does mention Fiji Hindi, but I'm still of the view that you can't really teach Fiji Hindi per se. Fiji Hindi has got its own limitations and issues. People speak differently, there's a lot of slang and so on. How will you teach? So what I'm saying is that, this is my personal perspective, that we already know we talk Fiji Hindi at home, it's different homes speak differently and so on. But it's going to be a mammoth task to bring all those different versions into literature and for the schools to actually teach. So what I'm saying is that the real Hindi is our root, and it's probably best that, it's in the constitution, Fiji Hindi, yes, fine, but we feel that the real Hindi should be taught if it is going to be that way.
Again, my question is, when you say real Hindi, which version are you talking about? But
Maybe
that's the point.
I'll
If
leave
you
it.
say the real Itoke, which version are you talking about?
Yeah.
Let's just move away from Hindi for a moment. If you
Right.
just look at the Itoke language, the Itoke language has different versions.
Different
I
dialects.
cannot understand one word of somebody who's from Nandronga who speaks in their dialect. Can't.
True.
Many other Itoke people probably don't. So how do you do that? The common ground here is conversant. If you look at the constitution, it says conversant. So it will be the job of the Ministry of Education to formalize that. Somehow or the other, formalize it. It's not a mammoth task. It is a language that has been developed over many moons, many years. And I'm talking about Itoke and also the Fiji Hindi. It has developed into a formal speaking language. Of course, yes, people from Lambasa speak different Hindi. Right? So again, it's like a bit of a dialect. So it's a very delicate operation in terms of this particular provision, which requires discussion like this. But it's something that needs to be talked about. It can't be buried under the carpet, and we can't bury our heads in the sand. I don't speak Hindi. I never learned Hindi. I never went to a school that taught Hindi. Many other children are like that. If somebody went to Sangam school, they would have been taught Tamil. Yes? Or Malayali for that matter. My parents never taught me Malayali. So the point here is that even when you say it, it has to be worded correctly. And please don't forget, this is an education act that has to carry us for the next 20 years or 10 years, or that's going to be reviewed. It hasn't been done in, I think it was if I'm correct, 1960 something. It's many moons ago that this was done. So if we're going to get it and we're going to set it in stone, we must get it correct. And you have gone around all the different schools. You don't have to answer us today. If you wish to deliberate on it and write to us, let us know. But, it would be nice to hear from you about finding the right path with respect to, no offense to anybody. We all speak it. Right? But for example, some of us only speak the Fiji Hindi. Even going on radio, we'll have to speak on Fiji Hindi. Not everybody gets instruction. Not everybody gets instruction. Can you imagine if somebody from Nandronga turned up and said, "Whoop, hang on, I want my one too." What are we going to say? The Chinese one, the Rotuman one. Where is it? So please ponder that. Let us know.
Probably, Commissioner, just to make everyone's life easier. This discussion has been ongoing for a very, very long time within our group, within all the submissions. And today, when we were discussing this with Ministry of Education, the E2K and Fiji Hindi is taught in primary school throughout, in most of the schools, I would say, but it's not an examinable subject because you can't take exams in Fiji Hindi. Absolutely, it would be a nightmare to do an exam because I come from Lambasa. My dialect is totally different from someone coming from the West. And we'll laugh at each other. But what this compulsory Hindi is for, not only for primary school, but for secondary school, or, from year 9 to 13, and then to university and so forth. And the idea that was floated was that whilst Fiji Hindi is, conversational Fiji Hindi is taught but not examinable, but Vasavakaviti and Hindi is the Sanskrit Hindi, that all the literature and everything that is in Fiji is written in Sanskrit Hindi. That will be taught as an examinable subject. And depending on the type of school, if it's a Chinese society-run school, they can teach their language, which is Cantonese or whatever it is. And then for Muslim-run schools, they can teach Urdu. If they want to, for a South Indian-run school, they can teach Tamil or Telugu, whatever they prefer. A school in Rambi may teach Rambian language for their understanding and for their preference. So this is what was discussed, because we need to have prepare our students not only for Fiji, but for the wider world. And in the wider world, English, Fijian to some extent, because we have diaspora everywhere, and Hindi is spoken not only in Fiji, not only in India, but other countries as well. So it's preparing our children for the wider world. That is what's important. Fiji Hindi is restricted to Fiji. There is no other country that speaks Fiji Hindi. There are other countries in the, like Trinidad and others, they speak Bhojpuri, a mix of Bhojpuri and other things. So it's important when we are developing our children, we holistically develop them for the wider world, not only concentrating on Fiji. So probably those are the things you also need to consider. I have a biased opinion, I don't want to say, but it's entirely up to you guys.
I think, yeah, just some final comments. So I think when we talk about Hindi, and just for, just to put it in clarity, because the Constitution says Itoke and Hindi, so we only looked at that. But you'll see our recommendation does say, and other languages spoken by students in their homes and communities. But as far as Hindi is concerned, if an Indian person in Fiji who speaks Fiji Hindi normally listens to or watches a program from India, I mean, India has got one Hindi, and that is the Hindi that's practiced globally. I mean, that's what they're trying to push. So we understand every single word that is, whatever we watch, whatever movies or whatever it may be. So we understand the genuine Hindi language out of India. We understand it very well. It's not that any person doesn't understand or cannot understand. So it's a little bit different from what Honorable Member said. With Itoke, it's totally different dialects. You don't understand what they are speaking. So many different dialects. But so when we say Hindi, I mean the Hindi coming out of India itself, there's only one Hindi, and that's what I was referring to. So it's a little bit easier for Hindi, but maybe not for the others.
Chair, and members of the Commission, can I please be excused for that? Thank you.
Thank you. Next.
Sorry. Next one is item number 15, Chair. It refers to clauses 44 to 46 that talks about boards and powers. Currently in the bill, as it is, there's no clear boundaries between, let's say, the education minister, the permanent secretary, boards, and principals. The cabinet terms of reference that was issued for the review of the Education Act required streamlining and clarifying roles and responsibilities. The bill currently leaves all operational role boundaries to Regulations Clause 175. There are no clear statutory boundaries separating policy decisions, such as from the minister, professional operations, such as the permanent secretary, governance, such as boards, and school management, such as principals. So this creates a risk of overlapping authority. And this is also mentioned in our Constitution, where it says good governance, including the limitation and separation of powers. So what we are suggesting, Chair and honorable members, is to define protected operational boundaries in the bill. 1, identify which powers are reserved for the permanent secretary explicitly. 2, identify which powers are delegated to school boards and school management committees. And 3, confirm that the minister may issue general policy directions but may not direct decisions in individual cases. So that will provide a better separation. Thank you, Chair.
Yep.
Are you referring to section 44 through to 46 in the bill?
Yes.
Now, this is only in reference to government schools. The provisions that are in that particular bill, in the bill, are only in reference to government schools. If you look at the heading, which says Division 2, it says government schools. The minister may, with the approval of cabinet, establish a government school.
Government-aided school.
So this is only relative to government schools, which fall under the authority of the government. So all of these necessary legislation that's being put in is only relative to government schools, and Division 3 will say government-aided schools. So is that the proposal that you've got in there from 44 through to 46 is with respect to both government and government-aided schools, or only for government-aided schools?
For both, eh? Honourable member, through you, Chair. Yes, 44 to 46. So
Both
covers
government
both.
and
Yes,
government-aided
yes,
schools?
Yes.
Okay.
Because even with the government-aided schools, the separation of power is important. That's what we're trying to say.
No, it's not something that is probably, it probably needs a little bit more vetting. I think if you look at the definition of government-aided schools, that will help you in determining, because there are a lot of schools that may have, we've had discussion with respect to the managers, etc., all that kind of stuff about it. So it is an area of contention for the committee to deliberate on. That's why I wanted to know whether you're only referring to government schools or government-aided schools also. Both. Okay.
Laka.
Thank you.
Next.
Next one is
Yeah.
number.
So,
Sorry,
yeah,
Priscilla.
that's me.
Laka.
Right. So I'm referring to number 17,
17.
clause 59. You'll find that on page 30. And it's regarding school closure. We'll note that with that clause 59 empowers the permanent secretary to close a school based on 8 grounds, and you see that 1 to H. But there is no provision for what happens to students or teachers after closure. And this is in regard to the student welfare. We need to be considerate and take care of the students already enrolled in those schools. What happens to them? There is no transition plan, there's no duty to relocate students. But when we compare this to clause 160 on higher education winding up, that requires at least 12 months notice, and that students' education is not affected. We recommend something similar here for schools that are closed down for whatever reason, that we insert a student welfare safeguard, and we insert a new clause. Before ordering closure, the PS must be satisfied about 3 things. Number 1, that the education will continue for affected students. Number 2, that other receiving schools would be identified that would take on board these students in the closed school. And number 3, that there should be reasonable transition arrangements in place to see that these students' education is not affected. Thank you, Chair. So we move on now to number 18, which is clause 59(1)(g). And one of the grounds for closure, number G, is that any person managing or assisting in the management of the school has been prohibited from serving in that capacity under section 166. So just because you close a school based on someone's disqualification, in this particular case, it could be the manager of the school, it would close down an entire school, thereby punishing all the students that are in that school. We would recommend that we reframe clause 59(1)(g), that instead of closure, the controlling authority is required to replace the prohibited person within a specified period of time. And number 2, closure should be a last resort only if the controlling authority fails to comply. Thank you, Chair. That's on that section. Moving on, number 19 is clause 63, which is on page 31, and this refers to school health and safety. We find that there is no legal duty to prevent bullying, harassment, or violence. Clause 63 focuses on hygiene, sanitation, and emergencies. There is no framework to prevent or address bullying, including cyberbullying, harassment, gender-based violence, or discrimination in schools. We recommend creating a safe learning environment and duty of care, which includes 1, inserting a new clause or expand clause 63, making sure that every school is providing a duty of care to maintain a safe and supporting learning environment free from bullying, harassment, violence, and discrimination. And number 2, require every school to implement policies to prevent and respond to harmful conduct and establish confidential reporting mechanisms. Next, number 20 on page 33, read the clause 69. It's on teacher-student ratio. We find that the teacher-student ratio is undefined. Clause 69.1 refers to a prescribed number of students, but no ratio is set in the Act, and prescribed is undefined. Without actual ratios, there is no meaningful constraint on class sizes. And from our school visits, Chair and members, we find that some of the urban schools are extremely difficult to teach in because they're really overcrowded. And so there needs to be some specified teacher-student ratio that needs, we suggest, is put in the Act. So set or require ratios by level. Ratios be prescribed in regulations by educational level. The Commission's recommended starting points are for early childhood education and development, 1:15, and that is already, I think, something that's prescribed for early childhood education. For primary schools, the prescribed we've seen is 1:30, but given the we have to be realistic about the conditions in our school and the overcrowdedness. We're suggesting a bit of flexibility here as to 1:35 students. And for secondary schools, we're recommending 1:40 students. For special and inclusive education, this is to be prescribed following consultation with special education experts. The recommended one for special schools is 1:1. In Fiji, it might be 1:4 students. So we thought we'd just leave that a little bit open-ended here in regard to the ratio for special and inclusive schools. We also recommend that the ratios be reviewed at least every 5 years and aligned with the free education grant formula.
Satisfied that they remain in the regulations, because 175G says teacher student ratios will be in the regulations. You're satisfied with that rather than putting it into the Act itself? 175G says you make regulations that do that.
Yes.
Okay, that's okay.
Well, we're suggesting that we might be a little bit more explicit and put down actual numbers so that schools and the government are regulated by
In the
that.
regulations rather than that.
The regulations is very broad, sir. It
No.
doesn't stipulate what...
No, what I'm saying is the regulation says that they have to make a regulation stipulating that. But the actual ratio is not written into the Act itself,
That's correct.
so that they can adjust it over time. So I'm asking you, okay, that it'll be kept in the regulations rather than in the mother legislation.
We are actually recommended that we bring it into the Act, sir.
Yeah.
Oh,
Yeah, inclusion in the Act. Well, for 5 years until the next review. Yeah? Okay. Up to, okay, one up to 30 students or 35 students.
why I'm asking that, because in your require ratios to be prescribed in regulations, the way that you put your
Oh, where?
recommendation here was in regulation, but the way that you're explaining it, I thought you were talking about the Mother Act himself.
Oh, I see what you mean. Yeah, so what we really wanted to see was it coming into the Act. We were referring to the regulation, which is very broad. Yeah.
Chair, if I may, just to assist you also, this has actually come up in our travels around the country also, in terms of the ratio, etc. But so you're suggesting that it be set in stone is it's not something that's not palatable outside. Everybody is saying that it should be done, because the end result is, because of the larger numbers per teacher, there are disciplinary issues. Because of you are not able, corporal punishment doesn't exist, etc., all that kind of stuff, it has created a major disciplinary issue. So when you say that, I'm sure that you would have met the same submissions on your travels. We have also. Yeah?
Concur on that. So can I move on to? Yes. Okay. So this one is number 21, and we're referring to clauses 72 and 156, that schools must hire counselors, but they actually don't receive any dedicated funding. We find this a really peculiar directive in regard to having counselors in each school across Fiji, but with no funding attached to it. And so Clause 72 requires every school to engage a counselor, as I said, but no earmarked funding is provided. This is an unfunded mandate. Rural schools cannot afford qualified counselors, and Clause 156 on the grants lists no specific student support or well-being category. So we recommend that we amend Clause 156 to add a mandatory grant category for student well-being and support, covering counseling, mental health, special needs, and other student support services. We reconsider the rigid requirement in Clause 72 for every individual school to have a counselor. We recommend allowing counseling and well-being services to be provided flexibly, including shared, district level, or divisional models, while ensuring every student has access to support.
If I may, Chair, I think it's a really important issue, because I think currently what is happening is those schools that do have counsellors are utilizing them for whatever disciplinary measures that need to take place. They're being sent to the counsellors because they can't undertake any discipline, even in the shape, form of some are actually not even doing detention because it's harmful to the students or whatever it is. So rather than actually fall under that umbrella, they're sending them to the counsellors. So it's an important point that you raised, that it should be funded, I think.
Honorable Chair, members, we move on to point number 25. This deals with financial management by schools. So currently there's no penalty for financial non-compliance. So Part 11 imposes financial duties, such as responsible management, records, statements, audits, annual reports. Yet in Part 15, the penalty section, it creates no offense for non-compliance. So a school manager, for example, could ignore financial reporting with no legal consequences. And in most cases, what happens if you don't comply, then your the education grant is delayed as well, and it affects the performance of the school and so on. So what we are saying is to insert a graduated enforcement mechanism. Number one, the permanent secretary may issue a written compliance direction with a deadline. And point number two, failure to comply after the direction is an offense. Fine not exceeding 5,000, maybe for the first offense, and 10,000 subsequent offense, just a suggestion. So there needs to be some form of a compliance mechanism where they are liable. Next one, Chair, is point number 26, part 11. This is to do with school funding. This is a very important point, also based on our findings on the ground, the schools that we have visited and consultations that we have had so far. There are no equity principles, no transparency requirements, and no protection against discrimination in school funding. So, for example, rural and maritime schools face higher costs, but receive no differential resourcing. It's all the same across the board. So the free education grant formula needs to account for location, accessibility, school size, and special needs. ECED, Early Childhood Education and Development, and special and inclusive education centers are the most critical and most underfunded parts of the education system. So what we're suggesting is require a equity-based funding model that accounts for location and accessibility, socio-economic context, school size, and special educational needs. 2, require the ministry to publish annual reports on grant allocations for category and school. 3, ensure that ECED and special and inclusive education centers receive appropriate differential funding. So what we are saying is there's need to change the formula. Thank you, Chair.
Shall we move on, Honourable Chair? Okay, thank you, Honourable Chair and Honourable Members. We're moving on to number 27. Is on part, which is to do with the FTRA, the Fiji Teachers Registration Authority. That there is an absence of the funding framework compared to the other statutory bodies. So it is a body corporate, as given in clause 84(2), with a staff, a CEO, committees, and board functions. And Part 12 contains no financial year, no funds clause, no grants clause, and no obligation on the minister to fund the FTRA. So we're recommending that we insert a finance division in Part 12, which is the same as what is given in clauses 153 to 156, page 57 to 58 on the Higher Education Commission, where we define the FTRA's financial year, list the funds of the FTRA fees, grants, and require the minister to allocate annual grants. I think the current practice is that the grant is given by the minister, but it's not given in, it's not stated specifically in the bill. So that is, Honourable Chair, if that can be part of the FTRA under Part 12. Thank you.
Honourable Chair and members of the committee, refer to you to item 34 in our submission, in which in turn refers to clause 162, minister not bound by advice. So the minister can ignore expert advice with no accountability. So clause 18 creates the Education Advisory Council to advise the minister, but clause 162 states the minister is not bound by its advice. There is no requirement to explain a rejected advice, table in Parliament, or acknowledge this publicly. So that derives from our issues paper, issue 29, in the Constitution, section 1G, transparency and accountability. So we recommend where the minister decides not to follow significant advice of the council, the minister must provide written reasons to the council. The council's advice and the minister's reasons must be tabled in Parliament at the earliest opportunity. And this is specific to the technical aspects of the council's deliberations.
Because in the curriculum authority, he is bound. Eh? But this is just general. This is talking about other stuff. Okay.
Thank you very much, Honorable Chani Usamate. So the next one item that I want to draw your attention to is 38, which refers to clause. Oh yes. Sorry, Chair. It's clause 36. The penalty structure is disproportionate. And we request that this be reviewed and we institute balanced penalties. So the issue, clauses 169 to 170 in the bill. So assaulting a student is 5,000 fine and 1 year in jail. Employing an unregistered teacher is 50,000 to 150,000, clause 170. False paperwork, 20,000, or 5 years imprisonment. And so the current penalty structure may convey that the administrative breaches are treated as more serious than physical harm to children. The clause 170 penalty provides no flexibility for emergency or temporary staffing situations caused by ministerial delays. So we recommend that increase the penalty for assaulting a student, 1692, up to 10,000, or imprisonment not exceeding 5 years or both, and review clause 170 penalty for proportionality and consider allowing a reasonable excuse defense for temporary staffing emergencies.
If I may, Chair. So effectively what you're saying is that 170 needs to be reviewed in terms of its proportionality, especially in the case of having an excuse or defense for temporary staffing emergencies. If you look back at what 170 says, employing an unregistered teacher, it's pretty serious. If you're doing false paperwork, it's pretty serious. So these clauses, when you look at it, do they really align to temporary staffing emergencies? Or is the school going to be not even going to get a slap on the wrist because it's got an unregistered teacher? Who stands to benefit here? Or who is this being done for? We are supposed to be protecting the children. So at the end of the day, if a school has gone wayward and conjured up false paperwork, do we go light on them?
Through you, Mr. Chair, I think Honorable Mr. Koya has got a good point. So we need to think a bit more about it. But having said that, currently there are a fair number of unregistered teachers teaching in schools currently. So there is a tussle between the FTRA and the Ministry of Education about this, gap. So, this is a problem.
I believe that implementing or coming up with a new mechanism, if there is a shortfall with respect to teachers, to fast track some teachers who may not be in quite registrable form but have the necessary nous or capability or straight out of school kind of thing to be able to do it, fast tracking that might be a avenue to do this rather than change the offense or the penalty, if you know what I mean. I think you're right, Professor. You find an avenue to facilitate rather than change the punishment, because these offenses are quite strong. Huh? That's basically our thoughts.
Thank you. We concede the point, Chair. And so the next one is 38. Sexual allegations against teachers should be a police case. So our reading of the clause 172 sexual allegations is that it deals with sexual misconduct allegations, but treats it only as a FTRA board matter, disciplinary matter. There is no requirement to refer the matter to police. And the fine of $1,000 is far too low. So our recommendation is that we should strengthen clause 172, require that any allegation of sexual misconduct involving a student be referred to the police force as well as the FTRA board, and increase the fine to at least 5,000 first offense and 10,000 for subsequent offense, signaling zero tolerance for this kind of conduct.
Just putting a lawyer's hat on. Right at the outset, you said if there is a sexual allegation. That throws a spanner in the works, doesn't it? It's an allegation. So I think maybe you're right, it probably needs to be worded correctly. Yeah? Because anybody can allege anything at the end of the day. That's certainly something that might need checking with the drafters.
Yes.
Yeah? Is that, you agree with that?
I agree with that completely.
Okay.
Yes.
Because this is being, what the reference in that 172 is that if there is an allegation involving a student and a teacher, the employing authority has undertaken measures that resulted in dismissal or resignation on the basis of allegation, not conviction. So you got to be careful. Huh?
Yes.
I think that's.
Of course, the usual principle applies. You're not guilty
Yes.
until you go through the process.
I mean, like you can say to them, take some leave without pay until all this is resolved, the matter is being reported to police, or whatever it is.
Yes.
The usual avenue. Yeah? Okay.
Yeah, in passing, just want to draw your attention to clause our item 39, review clause needing strengthening. Just to make the point, under recommendation 3, we need to sort of make a provision for an independent education commission or similar body that conducts a comprehensive review of the educational system at least every 10 years. We don't have to wait for 26.
Chair, we wanted that to be embedded into the Act, that every 10-year review should happen. So, Chair, now I take you to point number 43 of our submission. Yeah, it's under general orders. We note that two key education statutory bodies are not referenced in the bill. I think the idea was that all relative acts to do with education should be part of the Education Act. So we note that the Substance Abuse Advisory Council, SAAC, Act 1998 and the Tertiary Scholarships and Loans Service, TSLS. Two of these acts are actually missing from the bill, and we are suggesting to acknowledge and integrate these bodies. The bill should be formally reference both the SIAC Act 1998 and the TSLS Act 2014, or integrate their functions into the new framework. Two, reference the TSLS in Part 13, in brackets higher education, particularly in relation to Clause 130G on the allocation of government funds for higher education. There needs to be some reference made. Number three, reference the SAAC in Part 10, which is student behavior and well-being on student welfare matters. So that could be also referenced. And point number four, at minimum, add both bodies to the consultation requirements under Clause 14 or 18, the Education Advisory Council. So we felt that these two bodies are very important. We talked about, we have already Fiji Teachers Registration Authority, we have the Higher Education Commission of Fiji, but these two should be in the bill as well, in the act as well. Thank you, Chair. If there's no questions on that point, Chair, we have covered 21 of the 44 points that we have brought into the submission. We thought the 21 points were the critical ones for our verbal presentation this afternoon. And over the page, Chair and honorable members, for your benefit and ease of reference, we have highlighted the constitutional alignment, certain clauses of the actual Fiji Constitution. There's 9 points there that could be referred to because we, in any act, it has to align with the Constitution, obviously. And over the page, Chair and members, we also included observations of concern. We thought we put it in a list at the end, that these are also our concerns that may be considered by your committee, Chair and members. The first 6 is the substantive concerns, and the second 6 is drafting clarity. So we just leave it to the legal drafters to pick it up from there. Thank you, Chair.
Thank you very much. Honorable members, any comments to that? Honorable Sumate? Any comments? No? Okay.
Thank the Commission for a very detailed presentation. We thought we knew a lot. Now we just been on 5 weeks around Fiji on these things. But thank you for the things that you've raised. I thought I'd just say that.
Thank you. So, final comments to you, Chairperson, Professor Naidu.
Thank you, sir. We'd like to perhaps say 2 things. We were a bit concerned that we might have missed the bus with the education bill because the commission that was appointed to review the 1966 Education Act was established before us, and by the time we were appointed, they'd already submitted their report. So we are very grateful that there is this standing committee on justice, law, and human rights that's listening to submissions so we can make our input in this particular way. And of course, we spent the better part of a week going through the bill and made this observation. So it was very opportune that we had this opportunity and the privilege to come and have this conversation with you. So we'd like to thank you very much.
Thank you. Thank you very much, Professor Naidu. Probably I'll just air out our thanks, probably on behalf of the Honorable Speaker and the members of the committee. We thank you very much to you and the other commissioners who are present here, to your support staff. Thank you very much for a very well-detailed and articulated submission that we look forward to working with. Honorable Sumati has just said we've been on the road for 5 weeks trying to sort the education bill out and 2 other bills. This is one of the most controversial ones out there, a lot of views by the general public. But the task that I always try and remind the committee and we have to set one that lasts for 10 years. Okay? Because if we put one and then next year it's already amended, we didn't do a good job. Look at the 1966 Act. It stood the test of time. Only amended 7 times. 1966 Act. So with you being here, I know you'll contributed a lot more for us. The burden now is with us to look at what you have got for us and for us to try and do the education bill to become an act that probably will outlast the 1966 Act. We hope so. So 1966 Act only amended 7 times in its entire history. That's a very good, it shows the caliber of the Education Act that they did in colonial days. So without further ado, again, I thank you on behalf of the honorable members, and that adjourns our meeting for today. And for those of you who are tuning in live, thank you very much for tuning in live on the public submission today. That concludes our public submission from the Education Commission, and we wish you well for the rest of the day. Our submission is adjourned. Thank you.